Now we'll move to the actual hearing itself. When the motorist is served with a copy of the sworn report, either by mail or in person, they are then required to file, if they wish to contest that statutory summary suspension, they are required to file under 2-118.1 a petition to rescind the statutory summary suspension. And once they do that, the motorist does that, they must file and serve a copy upon the prosecutor or the city attorney, like any other notice of proceeding. How the matters are set, again, depends on what jurisdiction you're in. In some counties, the state's attorney will notice up the case, or local attorney, to have a hearing before the judge. In some of the larger counties, once the motorist files it, they're required to go to the clerk's office to see the judge's scheduler and get those dates. Either way, once the petition is filed by the motorist, defendant, it is incumbent upon the prosecuting agency, whether it is the state's attorney of the county or a local attorney, to in fact begin the process to get it scheduled. Now under subsection B, again we talked about it, but to reiterate, within 90 days after the notice is served, either by mail or personal, it is incumbent upon the motorist to make a written request for the hearing in that courthouse. 90 days. Is that 90 days mandatory? Only if the state's attorney holds them to that. If the state's attorney proceeds to a hearing where the petition is filed for more than 90 days out, the court then is reinvested with authority. So as the state's attorney's perspective, you get a petition to rescind filed by the motorist and the arrest has been long after 90 days. The state's attorney, you want to go in to court, file a written motion, notify the defense attorney, give a copy to the judge, and say, Judge, under this provision 118.1, this violates the provision and we're not agreeing to more than 90 days for the hearing and we want it dismissed. How does this hearing proceed? Well, first of all, once the court sets the hearing, the police officer is not required to be in court. The defense attorney may subpoena the officer, but again, depending on what jurisdiction you're in, may not be required to. If for some reason the officer does not come to court, the state's attorney or the local attorney may be able to proceed on the officer's sworn official reports. What's a sworn official report? There's no reported case in the state of Illinois what that is. At least the judge will be able to look at the paperwork in the file, and under there's certain a couple of cases, People versus Clayton and People versus Thomas, and under the statute where in fact the state's attorney can hand up to the judge a copy of the officer's police report. Whether the judge, if the motorist is able to shift the burden to the state's attorney, whether that's going to be enough to defeat the defendant's petition to rescind is going to be up to the court and up to the facts. So having said that, the scope of the hearing, although the statute provides certain parts of what the scope of the hearing may be, by case law there are other provisions that may be, you may proceed on for a petition to rescind the defense. There's case law that says that just because we have these 4 points doesn't mean that the hearing is limited to these 4 points. What are they? Number one, whether the person was placed under arrest for an offense as defined in 11-501 and given a ticket. In my years, I've seen very few cases, if almost any, where this is an issue. Number two, whether the officer had reasonable grounds to believe that the person was driving or in actual physical control of a motor vehicle upon a highway. Again, reasonable grounds is equated to probable cause. Number three, whether the person, after being advised by the officer, had a right to operate, and again, this would be a warning to motorists, would be suspended or revoked. The next one, whether the person, after being advised and the privilege, whether or not they submitted to a result of 08 or greater, or there was a urine or blood issue. Number five, which is a new part of the statutory summary suspension is if the person's driving privileges were revoked, whether the person was involved in a motor vehicle accident that had caused a type A injury to a death or another. Once the hearing is done, the court's either going to find that the suspension which is in effect will remain in effect, or that the defendant, in fact, has done a burden of proof.